Hi, I'm Carsen Tazi with Cal Family Solutions. We're a family law firm in the greater Sacramento and Placer area. In this video, we'll answer some common questions we receive about child custody. Let's begin with a fundamental question. What exactly does custody mean? Custody is a catch-all term for both legal custody and physical custody. Legal custody refers to the authority to make major decisions for and about your children, including, for example, decisions about schooling, participation in extracurricular activities, and non-emergency medical and dental care. Physical custody in California refers to whether the children will live with one parent or if the parents will each have significant time with the children. What people often mean when they say custody is the actual schedule or parenting plan. In California, this is called visitation, and it's separate from legal and physical custody. How is custody determined? Custody can be determined in one of two ways, by mutual agreement or by the court. The best way by far is for you and your ex to come to an agreement based on your specific situations and the needs of your own children. In California, most courts will start with the assumption that joint legal and joint physical custody is best for the children. From there, changes can be determined based upon the circumstances involved and what is in the children's best interest. In most situations, custody is either shared, called joint custody, or given to one of the parents, called sole custody. What should be included in a parenting plan? At a minimum, your parenting plan should address both legal and physical custody and a base parenting schedule, or what California calls visitation. In crafting your plan, it's important to recognize that time sharing and decision-making are independent concepts. In other words, you do not have to share parenting time equally in order to share decision-making authority. And sharing decision-making authority does not automatically mean that visitation with the children will be equally divided. You can agree on just about any parenting time arrangement that works for your family. For most families, having a predictable schedule that they can rely on assists the children with adjusting. Important factors to consider includes your children's ages and developmental needs, as well as the practical realities of transportation, work schedules, and living space. Your plan should recognize the importance of having your children spend quality time with both parents. Each parent should have blocks of work time and play time with the children. Depending on their ages, especially if they're young when you separate, the visitation schedule may change as your children get older. What happens if we can't agree? If you and your ex cannot work out a parenting plan on your own, then mediation is the best next step. This can be through a private mediator outside of court, with the assistance of an attorney, or through the court process itself. When filing a request with the court for orders involving custody or visitation, California requires that you attend mediation to try to resolve your disputes. Different counties handle this process in various ways, so be sure to see how your county approaches this process. At Cal Family Solutions, we strongly believe in out-of-court resolution where you and your ex can find ways to work together to make a custom plan focused specifically on the needs and desires of your children. Litigation can be costly, time-consuming, and emotionally wrenching. And when it's over, for all of your money, time, and tears, you may end up with a court-imposed parenting plan that neither of you may be happy with. Bottom line, if at all possible, find a way to agree on as much as possible. Here is another common question. My ex is a bad influence on my children. Can I keep him or her away from them? If your concern with your ex involves his or her parenting style, then probably not. For example, if you think your ex is a bad influence because he or she feeds the kids fast food and lets them stay up late watching TV, you'll need to work that out with your ex or learn to let it go. Courts rarely get involved in deciding who is a good parent and who is a bad parent. If, however, your ex presents a real danger to the children, then a court may intervene to ensure the children's safety. Even then, reduced or supervised visitation is often preferred over no contact at all. And one final question. We couldn't make our marriage work. How can we make a parenting plan work? There's no magic formula for successful co-parenting, but your experience will be improved if you understand and accept two things about parenting plans. First, no matter how complete you think your plan is, it cannot possibly cover every situation that might come up. Kids get older, schedules change, and life happens. You will have to be flexible and find a way to communicate as best as you can. Second, your parenting plan is an agreement between you and your ex. It will only work if you two honor and enforce it. A judge cannot resolve every minor dispute. A court cannot mandate respect, empathy, or common courtesy. Those essential aspects of successful co-parenting have to come from you and your former partner. If you have other questions about custody issues, we're here to help. Call us now at 916-287-3237 for a no-obligation consultation. We're here to help.